Ladies and gentlemen, good afternoon. My name is Cristina Macovei, and on behalf of the College of Europe, welcome to your webinar on the competition law and the age of algorithms, challenges and opportunities for the EU digital agenda. We will be happy to have here with us today Dr. Andrea RENDA, but before going into that, allow me to kindly introduce you the College of Europe briefly. The College of Europe was founded in 1949, and today we are delivering 5 master programs in Bruges and in Italy, and as from next academic year, we will have the 6th master program. The Development Office was founded in 1996, and since then, we are delivering professional executive education courses, as well as implementing and managing international cooperation projects funded by the EU and also other international donors. Allow me to say that Dr. Andrea RENDA is a visiting professor of the College of Europe since 2006, but he is also the head of the regulatory policy at CEPS, and he is also an adjunct professor at the Duke School of Law in Law and Economics. Before going to the presentation, allow me to present you the structure of the webinar today. The delivery of the webinar, it will be for more or less 30 minutes. The presentation of Dr. RENDA, 20 minutes, followed by a Q&A session and a brief introduction to our executive education course on EU competition law and IT markets. Allow me, before going to give the floor to Dr. RENDA, to say that the Q&A session is very, very interesting, first of all, to you, because you will have the opportunity to interact with Dr. RENDA live. By the way, he is live in the US. And also, as a suggestion, to kindly put your questions on the right side of the screen, you will see a box, and there you can basically address the questions, if possible, during the presentation of Dr. RENDA. Without further ado, Dr. RENDA, the floor is yours.
Thank you very much, Cristina. Thank you very much, Cristina, for the very nice introduction. And greetings to everybody that is remotely connected, and the ones that are also dealing with the organization of the webinar from Bruges directly. We have chosen a quite tricky topic to be dealt with in 20 minutes. So I will try to cover over the next 20 minutes as much as possible of the problems of the interaction between competition law and the online markets and algorithms. But of course, there will be a lot of room for additional qualifications and additional questions and hopefully answers, although there are many issues that are still pending and to which I might not have answers today. So I will just pose the open question for future research. So here's a little bit the issues that we're going to discuss today. I will walk you through some of the fundamentals of competition policy. I will admittedly be a little bit unsophisticated there, a bit rough because of time constraints, but I will use some of the graphs that are used in the very early years of university, not just because I want to bring you back to those early years, which for many people have been some of the happiest of your lives, but also because I think those same graphs that, this same basic graph that backs the overall application of competition law is then almost entirely reversed or turned upside down by digital markets. And algorithms make it even more weird to analyze. So let's go into that. Then I'll walk you through some of the reasons why digital markets have challenged or are challenging competition law. Then I will enumerate some of the issues that emerge with the use of algorithms in a number of fields, both for what concerns cartels and single firm conduct. And then I will close with some open questions. So let's go through the fundamentals. Why do we have competition law overall? And why have we had competition law since, at least here in the US, 1890, and since the Treaty of Rome at the EU level, and earlier than that for a number of countries also in Europe? Well, the reason is that competition law is a public policy intervention, and it's normally based on some form of market imperfection, or in some cases, even regulatory imperfections in the case of regulated monopolies. And many of you have studied this graph. I've seen from the list of participants that there are some of you who are actually very well educated, very well versed in this field. So I will be very brief. The reason is typically that compared to a perfectly competitive market, less competitive markets create losses in terms of social welfare, right? So here you have a typical case of a perfectly competitive market. Many small firms that cannot set the price. They adjust themselves to the market price, and this is an important issue that we will get back to when it comes to algorithmic pricing later on. They face a demand curve, which is typically downward sloping. You see this with the letter D there. And what emerges in a situation like this, under the typical conditions of perfect competition, that consumers can switch very easily, they have perfect information about prices and conditions of sale, products are homogeneous, there are no transportation costs, people behave rationally. Well, in these circumstances, what emerges is a price that is as low as the marginal cost and the average cost in the medium to long term, and a quantity which is the maximum possible quantity that can be sold sustainably on the market, meaning companies recover their costs, but they don't make supranormal profit. They only basically reap the rewards. They're the capital investment, but they only make normal profits, not above that. Now, compared to a situation like this, well, this situation is a situation in which the difference between what consumers would have been willing to pay for that product and what they actually paid, which is the price equal marginal cost line, is called consumer surplus, right? And this perfectly competitive market is the case in which the consumer surplus area is maximized. Compared to this, a non-competitive market, or the extreme of a monopoly, would be a situation in which a company can set the price, and the company would set the price in a way that allows that company to reap supranormal profits. So supra-competitive profits, this normally would be done by choosing the quantity at the point where the marginal revenue, marginal cost curves intersect, and creating a higher price that leads the company to reap these light blue areas of profits, which we call producer surplus. Now, the first impact of this change from competition to monopoly is a transfer, is a reallocation of resources. What used to be light gray, consumer surplus, is now light blue, producer surplus. But at the same time, there's less quantity being sold, and there are a number of consumers who would have bought the good under competition that do not buy this good. And the difference between EUComp and Q on the monopoly that you see on the horizontal line determines a loss in social welfare, which is this a red triangle, which we call deadweight loss. Now, you've seen that before. It's just to put everybody on the same page. But the existence of the deadweight loss, the fact that moving from a competitive market to a monopoly market leads to a net loss of social welfare, is the real basis for the existence of a public policy intervention that we call antitrust. There's also, of course, the reallocation effect, but the loss of the allocative efficiency that is determined by the transition from competition to monopoly is the actual justification, the actual market failure that backs antitrust. Now, antitrust at the EU level has also pursued other objectives, and many of you know market integration in particular, in some cases consumer welfare, more specifically in other cases even the protection of smaller and medium-sized enterprises. But the chief overarching reason why we have antitrust is the deadweight loss. And this graph we need to keep in mind because it will guide us through an analysis of what happens in digital markets. Because none of these dynamics actually are easily observed in digital markets. Well, it would take me like a full 3-hour class to go through all these effects. What I will do here is just list the effects that we observed since the mid-90s or the early 90s in digital markets that have led this overall graph to become less and less, let's say, actionable for competition authorities. And the first one is the fact that goods are digitized and they are information goods. They can be duplicated without losses in quality. They can be shared almost endlessly without big economies of scale observed, without the need to build additional plants. The fact that the marginal costs become close to zero or even zero in most of the purely software products. The end-to-end design of the internet, originally neutral design, has actually led this potential to be fully unleashed. And this has changed the way in which we observe pricing on the internet from the very beginning. At the same time, the products that back the use of the internet, the hardware software devices, are increasingly become modular since the early days of the personal computer. So there are several companies that cooperate within the same system. Over time, they become granular or even distributed, like in the case of blockchains today. And this makes it very difficult to locate one company that sells one product. It's rather groups of companies orchestrated by one company that takes the lead in a specific system, or even between peers, like in the case of open source software or Creative Commons products. And this also makes it very difficult to use standard antitrust tools to analyze market conduct. Other effects that have been very important, happy to discuss this in the Q&A, is the ongoing transition from property to access. And the fact that, for example, we have moved from download to own systems and online access to movies and songs to streaming services, which only give access to a functionality for a given amount of time or to a specific content for a given amount of time. Cloud computing is another such example. And this is typically coming with more blanket licensing and prices that are not specific to the possession of one unit of product. This also makes it difficult for competition authorities to track the price, see if there's a restriction to competition. At the same time, in the orchestration of these activities, many companies have come up with the needs to convey user attention towards a selection of content. And this has created multi-sided platforms that rely on direct and indirect network effects and typically gain a lot of prominence in the internet environment, and they compete to become the platform that will capture most of the user attention. This is what we call competition for eyeballs. Basically, what has happened in many of the internet markets is that companies try to get a hold of the scarcest resource that exists on the internet, which otherwise would be very similar to what we call perfect competition. The scarcest resource is user attention, right? And once a company has managed to conquer user attention, that attention can be monetized in several ways. So that company gains a whole lot of new possibilities to attract user attention, online advertising revenues, organization of a number of additional services. The company will become pivotal for at least one generation and will compete with all other companies that try to capture a share of the user attention. That company will not necessarily compete as vibrantly with similar companies that have lost the race for user attention. And this creates several headaches for competition authorities. You have to couple this with the fact that the internet is as an architecture that has been changing over time, and it changes over time. It changes with cloud computing, it changes with the Internet of Things, it changes with blockchain and the Internet of Value. There's been a lot of literature on the so-called platformization of the internet, and the fact that whenever the internet witnesses a specific concentration on one specific layer, think about, for example, search or online retail, this leads to concentration at that layer, but at the same time, platformization then leads to the blossoming of entry possibilities at other layers. For example, the existence of Android or iOS have led to a lot of new opportunities for companies like Uber or Airbnb to convey their products, to show their products to their customers, because they can go through app stores, right? So all this is particularly important when it comes to competition in these markets. If you go through the next slide, you will see one example of this, what we call competition for the market. In many of these markets, there are situations in which companies compete aggressively to become the leader of one generation. In the pre-selection of standard phase, there will be a competitive situation like the one you see on the screen. You will have a demand, you will have a price which is normally very low, and demand is also very low because no company is really emerged as a platform of their generation. as the Google for search or the Amazon for e-commerce, or previously the Microsoft for operating systems. Now, during this phase, consumer welfare is the area behind the demand curve and over the price. It's like area A, as you see there. When the market selects one standard, then the demand curve shifts outwards and becomes even more rigid because consumers will become more reluctant to abandon that standard. So there will be a situation that at the extreme might be a situation of monopoly for one generation. But the interesting thing is that, as you see in this graph, if the shift in the demand curve is sufficient, the consumer welfare under monopoly, area B, might be bigger than the consumer welfare under the previous phase. Now, this is what we call dynamic competition, is cases in which you might have overlapping generations of quasi-monopolists, but then all companies that have won this competitive race will need to keep competing to win the next generation of competitive race. Now, antitrust has to care about situations in which companies that have won the competitive race put in place strategies that might stifle competition for future generation of products. But all in all, to the extent that there can be generations, overlapping generations of quasi-monopolists with consumer welfare under one generation of monopolists being bigger than the pre-standard competitive consumer welfare, this can be welfare enhancing overall. And interestingly, what we observed online in that is that as companies keep winning the competitive race in what we call competition for the market or winner-take-all competition, once they have won, in order to win, they have to generate through multi-sided platforms new opportunities for players that maybe will become small complementors, small producers of applications at the beginning, but then will evolve later into competitors for these companies. So understanding these dynamics of competition is very difficult for a competition authority because competition typically comes from the future and even from friends in most cases or from application developers. Now, what are the consequences for antitrust? Very briefly, and then I turn to algorithms for the last minutes of my presentation. Well, competitors are often outside the relevant product market. It has happened in several cases. I'm happy to discuss that a competition authority defines a relevant market as encompassing players that are very different from the ones that the company considered to be dominant would consider to be its own rivals. Market shares, as a consequence, often make little sense. They have at least to be observed over a much longer period of time. Market power is very complex to identify, especially if one goes back to the original idea that market power is independence of behavior, or the ability, as the Court of Justice of the European Union would say, the ability to behave appreciably independently of competition, of competitors, customers, and ultimately consumers. Entry barriers change skin. Sometimes it might be difficult to enter a market when a company is leading that market in a specific moment of time, but competition comes typically from other relevant markets and from the future. So whether there are really entry barriers would need to be subject to a slightly or to a thoroughly different type of assessment. And even more importantly, since technology proves to be plastic and adaptable and markets change so often, remedies very often are ineffective and come too late. Now, I'm happy to qualify more all these statements in the Q&A, but in this helicopter view of what happens in online markets, I think the remedies part, the enforcement part, have to take a pretty important role because they are one of the issues that deserve more attention all in all. Now, what is happening with algorithms? And in most cases, these problems are being exacerbated by the pervasive use of algorithms by many companies in many parts of the economy. Now, algorithms in general are very good for competition. If you have been an economist over the past years, if you have specialized in economics, you might even get a little bit thrilled by algorithms because they promise the realization exactly of that type of perfect competition that we've been waiting for several decades. They lower search costs, they increase market transparency, they give access to an unprecedented array of products, services, alternative offers in various locations of the world. They blur geographic boundaries. They give also consumers the excitement of having the possibility of comparing prices through the use of algorithms. Now, there's several differences and several variants of algorithms used online, but just to give you an idea, it's not only the Googles, the Uber, the Airbnbs, Netflix or Expedia, or the Skyscanners that you see mentioned there in the slide. In a recent research, it was found that in Europe, 2/3 of online retailers are using algorithms to automatically adjust prices over time based on a number of specific parameters or on the observation of what other players are doing. So what is happening with algorithms is something that comes very close to perfect competition, meaning companies become price takers, meaning they observe price, they adjust to the market price, they don't set the price, they don't preserve their, let's say, niche of market power. So a question is antitrust needed at all as competition becomes so perfect? Well, let me be clear from the very beginning. Yes, antitrust is needed, but there might be changes that we need to introduce in antitrust. So let me go quickly through some of these problems. Let's think about cartels. One example being Topkins, or a case in the US, or another case like Aston, cases in which companies have been found to collude through algorithms on Amazon Marketplace by deciding to artificially set high prices. One of the main concerns is that the same thing that could be used to enable perfect competition could actually be used also for collusion. Self-learning algorithms can dilute liability. I can program an algorithm to over time adjust to future changes, and leads to what we would call tacit collusion or conscious parallelism between firms in a way that makes it very complicated for competition authorities to find out whether this was the result of competition or it was the result of collusion. The risk is that what is otherwise a very good thing, using algorithms to expand the possibilities for search and lower the search cost and increase market transparency, also becomes, is demonized as something that is always bad and leads to collusion. And some competition authorities have already started to worry a lot about the use of algorithms for price adjustments. Margrethe Vestager, the competition commissioner at the EU level, in March, already gave a speech in which she mentioned specifically the use of algorithms for price adjustments. There is a need for further research to really single out cases in which algorithms are being used for collusion and for competition, but it's going to be very difficult to do that without expanding the menu of tools of competition authorities, and in particular by using more technology. So the main problems would be finding evidence of intent or outcome, tracing market developments, establishing competitive price levels, monitoring conduct and future compliance. And the proposed solutions are not necessarily antitrust solutions. It's more like using technology to enter into those agreements and keep track of market prices, step up technology in support of end users, or use experimental forms of antitrust remedies such as collusion incubators or creating mavericks to really try and alter what otherwise would be conditions for a very stable collusive agreement. It's just a second to remind that when we think about the basic condition for cartels, one of those conditions is market transparency, which is a good thing, but at the same time enables observation of conduct of players. So let me get back to the original graph, and this is why I showed it to you in the very beginning. We have in those markets potentially two main effects that we don't know how to juggle with, and we don't know actually how to interpret. The first thing that happens in many of these online markets with algorithms, especially if data are available, is that companies can use data to really customize their offers to the willingness to pay of the end users. So the first effect that emerges in many cases is an effect like this, in which companies are able to capture all the consumer welfare and transform it into producer surplus. Now, interestingly, there's no deadweight loss in these markets, but at the same time, there's no consumer welfare left. And we don't know really whether this is entirely a good thing or it's partly also a bad thing. It depends on whether we adopt a social welfare or a consumer welfare standard. The other thing that might happen is that competition might either bring prices down even below cost due to real-time price wars, or what emerges in the market could be the result of an artificial agreement to charge super competitive pricing. Now, it is too complicated to deal with this as of now. I only have a couple minutes left in my presentation, but competition authorities should potentially research in the future how to analyze this potential coexistence and how possible would it be to collude in markets in which offers are purely customized based on data about the end users. This is an area that hasn't been fully analyzed yet, and I think it would be very interesting to analyze it in the future. Now, you have cases like this in which vendors really price at the same hours of the day in the same way on a specific platform, and we still don't know in what cases this is competition and in what cases this is collusion. Or you have cases in which algorithms clash and they determine market outcomes and price outcomes which are not even the result of the algorithm, but the result of an interaction between algorithms. You have cases in algo trading, such as the flash crash at 245 in May 2010, or you have cases like in Amazon, where a 20-year-old book on developmental biology, because of the interaction to algorithms, ended up costing in 2011 for a few hours $23 million. Is this something that depends on the algorithm? It depends on the interaction between the algorithms. Now, finally, on single firm conduct, we have a different set of problems compared to cartels, and equally intractable. Good example, the Google search investigation that has been going on for 8 years. It might be coming to an end soon, but we don't know exactly how. The main antitrust concerns are that companies that build winning algorithms can then leverage their market power in other markets and then discriminate by using these algorithms to their advantage and foreclosing other players. But at the same time, there are main risks that haven't been fully addressed there, jeopardizing dynamic competition just because we fear that leading algorithms might disadvantage existing players as opposed to future player, overlooking consumer benefits and harms. And so far, what we've observed are enormous problems in market definition, in the finding of dominance, in the finding of anti-competitive foreclosure, and the identification of suitable remedies. Currently, the proposed solutions are mandatory access and interoperability, but in the future, in my opinion, solutions will go more in the direction of algorithm auditing and accountability and stricter ex-ante and merger control, rather than imposing access ex post to algorithms, unless there is evidence that they really are thwarting competition. So we have, in this case, very briefly, another puzzle, which is algorithm is a trade secret. The algorithm is used to discriminate, which could be good or bad. Public authorities enforce antitrust rules by imposing changes in the algorithms, but the algorithm inevitably is changed very frequently, and public authorities cannot observe changes. So how do we deal with those issues? Another open question. And it's not just Google. The algorithm that Netflix uses, for example, explains 60% of its revenues in suggesting next movies to watch. Is this discriminating in favor of certain movies or others? The Facebook Messenger bots that are being developed will suggest service providers. Is this good or bad? Will it discriminate in favor of certain players or others? We don't know how to handle these problems, and it's going to be a very interesting issue to discuss in the future. So, few open questions, and I'll leave it there. Seems that these principles of antitrust are sound. Not sure about the tools. And the tools that are being used today sometimes are stretched and don't fully reflect the underlying principles. We need to research more on how to differentiate perfect competition from perfect collusion. We're not sure, and I'm not sure whether antitrust is always the best tool to address single firm use of algorithms. In some cases, data protection or cyber law tools are probably more predictable than antitrust tools. Given the different timings, should antitrust enforcement shift towards more ex-ante scrutiny? And should it rely more on technology? Again, a few examples that I made before. All these are open questions, in my opinion. I think it would be interesting to discuss them in class. I just wanted to set the stage for what I think is pretty much as a open air work that is being done by competition authorities and by scholars to try and get a hold of the problems and the differences and the discrepancies that separate the current work of competition authorities from the evolving dynamics of competition and the evolving economics of online markets, and in particular AI-powered algorithms. I stop here and I hand it over to Christina. hopefully has collected some.
Thank you so very much, Andrea, for this very insightful and interesting presentation. We did receive a question so far, which is, actually there are two by the same person. So the first question, perfect matching of supply and demand through algorithms brings allocative efficiency? Yes. The second one is price discrimination is always bad.
Yeah. Okay. Okay, I'll handle these two questions if you don't have others.
Please, I suggest to respond to these ones.
All right. First question, in principle, algorithmic pricing and the use of algorithms to navigate through pricing offers increase allocative efficiency because basically it leads to more competitive markets, greater market transparency, better switching by consumers in most cases, and better comparison of alternative offers. So in principle, it brings prices down towards the cost level and increases also the consumer welfare. Now, it increases the consumer welfare to the extent that there is no price discrimination. Otherwise, it would increase producer welfare. But in any case, algorithms have the potential to reduce the deadweight loss by increasing market transparency. So in principle, the answer is yes. Of course, it's going to be very complicated to understand when those algorithms are used in support of collusion. And I don't think we have gone any far in this respect. There has been a very famous book that I recommend, but at the same time, I think it's a bit too alarmist, by Ariel Ezraki and Maurice Stucke, called Virtual Competition, that analyzes the potential for algorithms to lead to collusion of various sorts. In my opinion, I think we haven't really gone very far in understanding how to use technology to navigate through market outcomes that are collusive and market outcomes that are competitive. Now, price discrimination is, of course, in most cases good, not bad. The fact that companies can charge to end consumers what they would be willing to pay typically expands the possibilities to reach out to different consumers in the market, so it expands opportunities. Of course, it also transforms consumer welfare into producer welfare, and to the extent that profits are reinvested into innovation, like many online companies do, this could also be good for dynamic efficiency. But price discrimination in other cases is also an antitrust violation. So again, understanding what the limits are and when price discrimination is indeed an antitrust violation, and when, as to use terms that are used in antitrust, a dominant company applies different conditions to equivalent transactions in a way that leads to exploitative abuses, then this is something that in online markets, in my opinion, is far from clear. It has to be subject to future research, the extent to which price discrimination will have to be demonized in antitrust, or it's something like much more of a normal feature of cases in which there's so much more information about end users that you could charge different prices to different people and reach out to many more consumers.
Thank you so very much, Andrea, for this reply. I see that there are still two more questions, or actually three questions. However, the time is running, so what I will suggest is to take these questions and to answer them via an email if it's fine for everybody, and for you, Andrea, of course. Thank you so very much, Andrea, for your intervention and contribution today. We are very, very honored to have you with us. Before ending this webinar, I see that the questions are keep on coming. As I've mentioned, all of them will be answered and sent to all of you in an email. So please still address us questions if you have any of these. So no problem to receive them and to answer. Before ending this webinar, allow me to introduce you briefly the program of the EU Competition Law and IT Markets that we have this summer in the Bruges campus of the College of Europe that will take place between 10 and 19 July. And this executive education course is structured in a very interactive manner, tackling relevant topics of EU competition law and IT markets. The design allows interaction with the trainers and also the fellow participants. Program includes Article 101, horizontal and vertical restraints, mergers and acquisitions, abuse of dominant position, as well as other sessions on the Google investigations, data mergers and distributions in the digital age. Should you be interested in our courses, please visit our website coleurope.eu/EUCompetitionLaw. And for more information on our executive education courses, please visit coleurope.eu/executiveeducation. Thank you so very much once again for participating in this webinar. Thank you, Andrea Renda, once again. And I would like to give a warm thank you to the team behind the scenes. This is Letizia, Maureen, and Kim. Thank you so very much, and looking forward to welcome you in Bruges. Thank you.